Q. While driving his car along EDSA, Caesar sideswiped Roberto, causing injuries to the latter. Roberto sued Caesar and the third-party liability insurer for damages and/or insurance proceeds. The insurance company moved to dismiss the complaint, contending that the liability of Caesar has not yet been determined with finality. Is the contention of the insurer correct? A. No, the contention of the insurer is not correct. There is no need to wait for the decision of the court determining Caesar's liability with finality before the third-party liability insurer could be sued. The occurrence of the injury to Roberto immediately gave rise to the liability of the insurer under its policy. Where an insurance policy insures directly against liability, the insurer's liability accrues immediately upon the occurrence of the injury or event upon which the liability depends. Schaefer vs. RDC Judge, Supra. Liability of insurer if the insured was committing a felony. Liabilities arising out of acts of negligence, which are also criminal, are also insurable on the ground that such acts are accidental. Thus, a motor insurance policy covering the insured's liability for accidental injury caused by his negligence, even though gross and attended by criminal consequences such as homicide through reckless imprudence, will not be void as against public policy. But liability consequences of deliberate criminal acts are not insurable. Sundeong Sr. and Aquino, 2014. No action clause. It is a requirement in a policy of liability insurance which provides that suit and final judgment be first obtained against the insured, that only thereafter can the person injured recover on the policy. It expressly disallows suing the insurer as co-defendant. A no-action clause must yield to the provisions of the rules of court regarding multiplicity of suits. Rules in Accident Insurance 1. For death or injury to be covered by the policy, such should not be the natural or probable result of the insured's voluntary act, or if something unforeseen occurs in the doing of the act which produces the injury, which may result to death. 2. Suicide and willful exposure to needless peril are in pari materia because they both signify a disregard for one's life. Voluntary exposure to a known danger is generally held to negate the accidental character of whatever followed from a known danger. 3. The insured's beneficiary has the burden of proof in demonstrating that the cause of death is due to the covered peril. Once that fact is established, the burden shifts to the insurer to show any accepted peril that may have been stipulated by the parties. Suretyship contract of suretyship. It is an agreement whereby a party called the surety guarantees the performance by another party called the principal or obligor of an obligation or undertaking in favor of a third party called the obligee. It is essentially a credit accommodation which includes official recognizances, stipulations, bonds, or undertakings issued by any company by virtue and under the provisions of Act No. 536, as amended by Act No. 2206. The extent of surety's liability is determined by the language of the suretyship contract or bond itself. It cannot be extended by implications beyond the terms of the contract. Having accepted the bond, the creditor is bound by the recital in the surety bond that the terms and conditions of distributorship contract be reduced in writing or at the very least communicated in writing to the surety. Such non-compliance by the creditor impacts not on the validity or legality of the surety contract but on the creditor's right to demand performance. First Lepinto Taisho Insurance Corporation vs. Chevron Philippines, GR number 177839, January 18, 2012. Nature of liability of surety. The liability of the surety or sureties shall be 1. Solidary joint and several with the obligor, and 2. Limited or fixed, limited to the amount of the bond. 3. Contractual, it is determined strictly by the terms of the contract of suretyship in relation to the principal contract between the obligor and the obligee. Suretyship vs. property insurance. Suretyship property insurance. It is an accessory contract. The principal contract itself. There are three parties, the surety, obligor/debtor, and the obligee/creditor. There are only two parties, insurer and insured. More of a credit accommodation with the surety assuming primary liability. Generally a contract of indemnity. Surety is entitled to reimbursement from the principal and his guarantors for the loss it may suffer under the contract. No right of recovery for the loss the insurer may sustain except when the insurer is entitled to subrogation. A bond may be cancelled by or with the consent of the obligee or by the commissioner or by the court. May be cancelled unilaterally either by the insured or by the insurer on grounds provided by law. Requires acceptance of the obligee before it becomes valid and enforceable. Does not need acceptance of any third party. A risk-shifting device, the premium paid being in the nature of a service fee. A risk-distributing device, the premium paid being considered a ratable contribution to a common fund. Types of surety bonds. 1. Contract bonds. These are connected with construction and supply contracts. It protects the owner against a possible default by the contractor or his possible failure to pay materials, men, laborers, and subcontractors. The position of surety, therefore, is to answer for a failure of the principal to perform in accordance with the terms and specifications of the contract. There may be two bonds. A. Performance bond covers the faithful performance of the contract, and B. Payment bond covers the payment of laborers and material men. 2. Fidelity bonds. They pay an employer for loss growing out of a dishonest act of his employee. For the purposes of underwriting, they are classified as A. Industrial bond, required by private employers to cover loss through dishonesty of employees, and B. Public official bond, required of public officers for the faithful performance of their duties and as a condition of entering upon the duties of their offices. 3. Judicial bonds, required in connection with judicial proceedings. Rules of payment of premiums in suretyship. 1. The premium becomes a debt as soon as the contract of suretyship or bond is perfected and delivered to the obligor. 2. The contract of suretyship or bonding shall not be valid and binding unless and until the premium therefore has been paid. 3. Where the obligee has accepted the bond, it shall be valid and enforceable notwithstanding that the premium has not been paid. 4. If the contract of suretyship or bond is not accepted by, or filed with the obligee, the surety shall collect only a reasonable amount. 5. If the non-acceptance of the bond be due to the fault or negligence of the surety, no service fee, stamps, or taxes imposed shall be collected by the surety. And 6. In the case of continuing bond, the obligor shall pay the subsequent annual premium as it falls due until the contract is cancelled. By law and by the specific contract involved in this case. The effectivity of the bond required for the obtention of a license to engage in the business of receiving rice for storage is determined not alone by the payment of premiums but principally by the administrator of the NFA. A continuing bond, as in this case where there is no fixed expiration date, may be cancelled only by the obligee, which is the NFA, by the insurance commissioner, and by the court, Country Bankers Insurance Corporation vs. Lagman, GR number 165487, July 13, 2011, in Divina, 2014. Q. Fumi Technics Corporation, represented by Malords Apostol, had applied for and was issued a surety bond by First Lepintotasio Insurance Corporation for the amount of P15,700,000.00. As stated in the attached rider, the bond was in compliance with the requirement for the grant of a credit line with the Chevron Philippines, Inc. to guarantee payment of the cost of fuel products withdrawn within the stipulated time in accordance with the terms and conditions of agreement between Chevron and Fumi Technics. When Fumi Technics defaulted on its obligation, Chevron notified First Lepintotasio of Fumi Technics' unpaid purchases. First Lepintotasio thereafter demanded to Fumi Technics the submission of a copy of the agreement secured by the bond, together with copies of documents such as delivery receipts. Fumi Technics, however, denied that it executed such an agreement with Chevron, thus no copy of such agreement could be submitted. Because of this, Chevron Philippines, Inc. sued First Lepintotasio for the payment of unpaid oil and petroleum purchases made by Fumi Technics. Is the surety liable to the creditor in absence of a written contract with the principal? A. No. Section 176 of the Insurance Code is clear that a surety contract should be read and interpreted together with the contract entered into between the creditor and the principal. A surety contract is merely a collateral one, its basis is the principal contract or undertaking which it secures. Necessarily, the stipulations in such principal agreement must at least be communicated or made known to the surety. Having accepted the bond, Chevron as creditor must be held bound by the recital in the surety bond that the terms and conditions of its distributorship contract be reduced in writing or at the very least communicated in writing to the surety. Such non-compliance by the Chevron impacts not on the validity or legality of the surety contract but on the creditor's right to demand performance. First Lepintotasio Insurance v. Chevron Philippines, Inc., Gr. No. 177,839, January 18, 2012. Life insurance. It is insurance on human lives and insurance appertaining thereto or connected therewith. Seconds. 181, Insurance Code. It includes every contract or pledge for the payment of endowments or annuities. It is made payable on the death of the person, or on his surviving a specified period, or otherwise contingently on the continuance or cessation of life. Note: every contract or undertaking for the payment of annuities including contracts for the payment of lump sums under a retirement program where a life insurance company manages or acts as a trustee for such retirement program, shall be considered a life insurance contract for purposes of the Insurance Code. Every contract or pledge for the payment of endowments or annuities shall also be considered a life insurance contract under the Insurance Code. Who may exercise any right under the policy in the absence of a judicial guardian, the father, or in the latter's absence or incapacity, the mother, of any minor, who is an insured or a beneficiary under a contract of life, health, or accident insurance, may exercise, in behalf of said minor, any right under the policy, without necessity of court authority or the giving of a bond. Where the interest of the minor in the particular act involved does not exceed 500,000 pesos or in such reasonable amount as may be determined by the Commissioner. Such right may include, but shall not be limited to, obtaining a policy loan, surrendering the policy, receiving the proceeds of the policy, and giving the minor's consent to any transaction on the minor's consent to any transaction on the policy. In the absence or in case of the incapacity of the father or mother, the grandparent, the eldest brother or sister at least 18 years of age, or any relative who has actual custody of the minor insured or beneficiary, shall act as a guardian without need of a court order or judicial appointment as such guardian, as long as such person is not otherwise disqualified or incapacitated. Payment made by the insurer pursuant to this section shall relieve such insurer of any liability under the contract. Reasons why a life insurance is also a contract of indemnity. This is because of the following reasons. 1. The liability in life insurance is absolutely certain. 2. Amount of life insurance generally is without limit. 3. The policy is a valued policy. 4. There is no direct pecuniary loss required. Kinds of life insurance policies. 1. Group life, essentially a single insurance contract that provides coverage for many individuals. Example, in favor of employees, mortgage redemption insurance. 2. Ordinary life, general life, or old line policy. Insured pays a premium every year until he dies. 3. Limited payment, insured pays premium for a limited period. If he dies within the period, his beneficiary is paid. If he outlives the period, he does not get anything. 4. Industrial life, entitles the insured to pay premiums weekly, or where premiums are payable monthly or oftener. 5. Term insurance, insured pays premium only once, and he is insured for a specified period. If he dies within the period, his beneficiaries benefit. If he outlives the period, no person benefits from the insurance. 6. Endowment, insured pays premium for specified period. If he outlives the period, the face value of the policy is paid to him. If not, his beneficiaries receive the benefit. Sundeong Sr. and Aquino, 2014. Contract of life annuity. It is a contract to pay the insured, or a named person or persons, a sum or sums periodically during life or certain period. Measure of indemnity under a policy of insurance upon life or health. GR. The measure of indemnity under a policy of insurance upon life or health is the sum fixed in the policy. XPN. The interest of a person insured is susceptible of exact pecuniary measurement. Liability of the insurer. In case of suicide, the insurer shall be liable in case of suicide by the insured if 1. The suicide is committed after the policy has been in force for a period of 2 years from the date of its issue or of its last reinstatement. 2. The suicide is committed within a shorter period as provided in the policy. 3. The suicide is committed in the state of insanity regardless of the date of commission, IC, seconds. 183. Note: any stipulation extending the 2-year period is null and void. Q. Sun Insurance Co. issued to TAN a life policy having this provision. The company shall not be liable in respect of bodily injury consequent upon the insured person who willfully exposes himself to needless peril except in an attempt to save human life. TAN designated his wife, Beverly, as beneficiary. One evening, TAN, while playing with his handgun, suddenly stood in front of his secretary and pointed the gun at her. Startled, she pushed the gun aside and said that it may be loaded. Thus, TAN, to assure her that it was not loaded, pointed it at his temple. The next moment, there was an explosion and TAN slumped to the floor lifeless. Beverly then claimed the proceeds from Sun Insurance, but the latter rejected her claim on the ground that the death of TAN was not accidental. Beverly sued the insurer. Will Beverly's claim prosper? A. Beverly can recover the proceeds of the policy from the insurer. The death of the insured was not due to suicide or willful exposure to needless peril, which are accepted risks. The Insured's Act was purely an act of negligence which is covered by the policy and for which the insured got the insurance for his protection. In fact, he removed the magazine from the gun, and when he pointed the gun to his temple he did so because he thought that it was safe for him to do so. He did so to assure his sister that the gun was harmless. There is none in the policy that would relieve the insurer of liability for the death of the insured, since the death was an accident. Life insurance vs. fire/marine insurance. Life insurance fire/marine insurance. It is a contract of investment, not contract of indemnity. It is a contract of indemnity. Always regarded as valued policy. May be open or valued. May be transferred or assigned to any person even if he has no insurable interest. The transferee or assignee must have an insurable interest in the thing insured. The consent of the insurer is not essential to the validity of the assignment of a life policy unless expressly required. Consent, in the absence of waiver by the insurer, is essential in the assignment of the policy. Insurable interest in the life or health of the person insured need not exist after the insurance takes effect or when loss occurs. Insurable interest in the property insured must exist not only when the insurance takes effect but also when the loss occurs. Insurable interest need not have any legal basis. Insurable interest must have a legal basis. Contingency that is contemplated is a certain event. The contingency insured against may or may not occur. The liability of the insurer to make payment is certain, the only uncertain element being when such payment must be made. Liability is uncertain because the happening of the peril insured against is uncertain. May be terminated by the insured but cannot be cancelled by the insurer and is usually a long-term contract. May be cancelled by either party and is usually for a term of 1 year. The loss to the beneficiary caused by the death of the insured can seldom be measured accurately in terms of cash value. The reverse is generally true of the loss of property, i.e., it is capable of pecuniary estimation. The beneficiary is under no obligation to prove actual financial loss as a result of the death of the insured in order to collect the insurance. The insured is required to submit proof of his actual pecuniary loss as a condition precedent to collecting the insurance. Compulsory motor vehicle liability insurance. Motor vehicle liability insurance. It is a protection coverage that will answer for legal liability for losses and damages for bodily injuries or property damage that may be sustained by another arising from the use and operation of a motor vehicle by its owner. Note: it is the only compulsory insurance coverage under the Insurance Code. The Insurance Code makes it unlawful for any land transportation operator or owner of a motor vehicle to operate the same in public highways unless there is an insurance or guarantee to indemnify the death or bodily injury of a third party or passenger arising from the use thereof. Registration of any vehicle will not be made or renewed without complying with the requirement. Purpose of motor vehicle liability insurance: to give immediate financial assistance to victims of motor vehicle accidents and/or their dependents, especially if they are poor regardless of financial capability of motor vehicle owners or operators. Responsible for the accident sustained. Note: the insurer's liability accrues immediately upon the occurrence of the injury or event upon which the liability depends, and does not depend on the recovery of judgment by the injured party against the insured. Schaefer v. Judge, RDC, Supra. Definitions. 1. Motor vehicle: any vehicle propelled by any power other than muscular power using the public highways, but excepting road rollers, trolleys, cars, street sweepers, sprinklers, lawn mowers, bulldozers, graders, forklifts, amphibian trucks, and cranes if not used in public highways, vehicles which run only on rails or tracks, and tractors, trailers and traction engines of all kinds used exclusively for agricultural purposes. Seconds 3 of RA 4136. Note: trailers having any number of wheels, when propelled or intended to be propelled by attachment to a motor vehicle, shall be classified as separate motor vehicle with no power rating. 2. Passenger: any fare-paying person being transported and conveyed in and by a motor vehicle for transportation of passengers for compensation, including persons expressly authorized by law or by the vehicle's operator or his agents to ride without fare. 3. Third party: any person other than a passenger as defined in this section, and shall also exclude a member of the household, or a member of the family within the second degree of consanguinity or affinity. Of a motor vehicle owner or land transportation operator, as likewise defined herein, or his employee in respect of death, bodily injury, or damage to property arising out of and in the course of employment. For owner or motor vehicle owner. Actual legal owner of a motor vehicle, whose name such vehicle is duly registered with the Land Transportation Office. 5. Land Transportation Operator. The owner or owners of motor vehicles for transportation of passengers for compensation, including school buses. Persons required to maintain a compulsory motor vehicle liability insurance policy to operate motor vehicle/s in public highways. 1. Motor vehicle owner. 2. Land transportation operator, seconds. 387, IBID. Scope of coverage required for compulsory motor vehicle liability insurance. 1. For MVOs, the coverage must be comprehensive against third-party liability for death or bodily injuries. If the private motor vehicle is being used to transport passengers for compensation, the coverage shall include passenger liability. 2. For LTOs, coverage must be comprehensive against both passenger and third-party liabilities for death or bodily injuries, INS. Memo. Sir No 3-81. Substitutes for a compulsory motor vehicle liability insurance policy. Instead of a CMVLI policy, MVOs or LTOs may either 1. Post a surety bond with the insurance commissioner, who shall be made the obligee or creditor in the bond in such amount or amounts required as limits of indemnity to answer for the same losses sought to be covered by a CMVLI policy, or 2. Make a cash deposit with the insurance commission in such amount or amounts required as limits of indemnity for the same purpose. After the cash deposit or surety bond has been proceeded against by the insurance commissioner, such cash deposit shall be replenished or such surety bond shall be restored by the MVO or LTO in the right amount/s required as limit of liability within 60 days after impairment or expiry, otherwise he shall secure a CMVLI required. Duties of motor vehicle owner or land transportation operator in contemplation of the cancellation of the policy. Contemplating the cancellation of the policy, the MVO or LTO shall 1. Give to the insurance or surety company concerned a written notice of his intention to cancel. 2. Secure, before the insurance policy or surety bond ceases to be effective, another similar policy or bond to replace that one cancelled. 3. Without making any replacement, make a cash deposit in sufficient amount with the insurance commissioner and secure a certification from the insurance commissioner regarding the deposit made for presentation to and filing with the Land Transportation Office, CMVLI. Supra. Limitations with respect to compulsory motor vehicle liability insurance over solicitation. 1. No government office or agency having the duty of implementing the provisions of the Insurance Code on CMVLI shall act as agent in procuring the insurance policy or surety bond required. 2. No official or employee of such office or agency shall similarly act as such agent. And 3. The commission of an agent procuring the corresponding insurance policy or surety bond shall in no case exceed 10% of the amount of premiums therefor. Effects of the cancellation of the policy. Upon receipt of the notice of such cancellation, the Land Transportation Office shall order the immediate confiscation of the plates of the motor vehicle concerned. XBNs. No confiscation will be ordered if said office receives any of the following. 1. An evidence or proof of a new and valid CMVLI cover, which may be either an insurance policy or guarantee in cash or surety bond. 2. A signed duplicate of an endorsement or addendum issued by the insurance company concerned showing revival or continuance of the CMVLI cover, or 3. A certification issued by the insurance commissioner to the effect that a cash deposit in the amount required as limit of indemnity has been made with him by the MVO or LTO. Own damage coverage. It simply meant that the insurer had assumed to reimburse the costs for repairing the damage to the insured vehicle, as opposed to damage to third-party vehicle/property. The phrase own damage does not mean damage to the insured car caused by the assured itself, instead, of third parties.